Court rise. Appeal in the matter of Hallett and the Derby Hospitals NHS Foundation Trust.
Derby, I think. Yes, Mr. Kavanagh.
May it please the Court, I appear along with Miss Sarah Keogh for the appellant, Dr. Sarah Hallett,
Yes.
who's acting in a representative capacity, as the Court would have seen.
Yes.
My learned friend Richard Leeper QC appears for the Respondent Trust. The Secretary of State for Health, represented by Mr. Adrian Lynch QC, has recently made an application to intervene in these proceedings.
Yes.
And the Court, by my Lady Justice Nicola Davies, ordered that application should be dealt with first this morning.
Yes.
So if it's convenient to the Court, I'll cede the floor to him.
Yes.
My Lord, my Lady, first, an expression of genuine gratitude that you are hearing me this morning on this application. I'm very conscious indeed of the need for speed, so do please stop me if I'm rushing too much. In that regard, in terms of the speed, of course that applies not just to this bit I say now, but to my submissions overall because of the timing for the appeal. And I thought I might start my application by referring to the issues I will cover if allowed to intervene, to underline and underscore how swift they will be.
Well, just tell us what it is that you seek to tell us about, which we don't know already. The parties were very competently represented at trial and will be here. It isn't usual to allow any new evidence to be adduced on appeal unless it's entirely uncontroversial and accepted by everybody. And I just wonder what it is that your new material tells us. Let me put to one side. It tells us that there are 233 NHS trusts and that there are 51,000-ish junior doctors covered by this. I'm sure Mr. Kavanagh wouldn't object to our knowing that if we don't know it already. What else does your material tell us?
Well, my Lord, I'm very grateful for the question. I mean, it goes to the centrepiece, of course, and my response is that in regard to the material and statistics about the NHS the data, which my Lord, I entirely, if I may respectfully agree, is not contentious. That goes to indicating the significance of the case generally, but more specifically, we will be submitting, if allowed to, that it is relevant in terms of the submission on the part of Dr. Hallett, that the arrangements in place in the NHS Trust were irrational. And the reason why we say it's relevant to that is that we do know, even though these specific figures are are not agreed, but we know, and it's been found by the High Court, that on any view, the system used by the Royal Derby Trust was commonplace throughout the NHS, not putting a precise figure on it, but it is clear many other trusts followed exactly the same pattern. We will submit that it may be that my lords and my lady will be assisted in terms of assessing that submission in regard to supposed irrationality, to have a sense of how far it reaches. It is, even if only 50% of trusts use that same system, it would mean that around 116 or so trusts did so. 26,000 junior doctors were subject to it. And the New Deal in its full flow existed in England between 2002 and 2016, and it persists in other parts of the United Kingdom. Yeah. Now we submit, my lords and my lady may be assisted in having that emphasised in terms of, is it really the case that it was irrational for the Royal Derby Trust to adopt such an approach shared by so many? That's that point. Then in regard to another point of great significance in this case, that is, of course, which documents governed the monitoring procedures. And in that regard, the essential debate is that my learned friends, on behalf of Dr. Hallett, argued in the High Court, and will argue, no doubt, for my lord and my lady, that it was the documents central NHS, so to speak, the Department of Health, as it then was, that governed the general terms and conditions that applied, were governing, as was the general guidance from the Department of Health. Now, of course, the Royal Derby Trust submitted, and the High Court accepted that's not right, and that it was actually the local trust, the Royal Derby Trust, and its documents that governed, in essence, the relevant procedures, and that took, of course, the High Court to the contract of employment between Dr. Hallett and the Royal Derby Trust, and the guidance and FAQs that were published by the Trust. Now, that's a central question. I won't be taking up the Court's time by delving into the contractual provisions and repeating what my expert learned friends on both sides have submitted and will submit. But what I would seek to do on behalf of the Secretary of State for Health is to say, stepping back a block or two, we have a system in the NHS, and have had for many years, which encourages autonomy and self-determination amongst local trusts. Allowing trusts, such as the Royal Derby Trust, that freedom, a finding that it was the local trust that was determinative of the arrangements, was wholly consistent with that philosophy. Now, as I say, obviously I appreciate the centrepiece of this case is the contractual provisions. I won't be delving into that at all.
How does the rationality arise?
The rationality applies, as I understand it, my lord, in the following way, that my learned friends on behalf of Dr. Hallett have their arguments about what the governing documents are, but they then submit that even if they are wrong about that, and even if the High Court was not in error in coming to the conclusions that it did, that the local documents were determinative, the High Court, as a result, found that the methodology in place was of a particular type for monitoring, and my learned friends, as I understand it, argue, even if that's true, it's of no value, because that system was irrational and therefore void, not part of the contract, and therefore that system can't be relied upon. So it arises, my lord, as a kind of, I wouldn't say long stop at all, but nevertheless, it's an argument that's developed in the alternative by my learned friends on behalf of Dr. Hallett, but that's how it would arise if it arises, and that's why it is a relevant consideration. Now, as I say, I'm not claiming that as the Secretary of State, although we're very grateful if we could be represented and answer questions, for example, if the Court has any. But although we have a clear interest in this matter, of course, I don't want to pretend I'm going to try to repeat anything my learned friends have said. But we do think we have a contribution in the way that I've indicated, quite apart from answering any questions that my lords and lady might have. So, in a nutshell, that really is how we put our application. I mean, I don't know whether I can be more helpful on that point, or indeed any other points.
I think you've set out your stall for present purposes. Thank you very much, Mr. Lynch.
Not at all. I mean, I don't know whether it'd be helpful if I press on in terms...
No, don't press on. There's the whole question is whether you should be allowed to press on.
Yeah, exactly.
And if so, at what stage and in what form.
Exactly right. So my lord, I obviously it'd be presumptuous to go to part 19.2 of the White Book and all that. My lords and my lady are far more familiar than I, so I won't presume to develop those submissions. But if my lords and my lady are troubled about anything, then I have, of course, submissions to make, slotting in why I respectfully submit we should be allowed to intervene.
Yes, right. Thank you.
Thank you very much.
Mr. Leeper, are you maintaining studious neutrality?
Indeed.
Yes, thank you very much. Mr. Kavanagh?
My Lord, sadly, we're not neutral.
No.
In our respectful submission, there are 3 reasons why this court should not permit the Secretary of State to intervene at this stage. The first one is that the intervention serves no purpose, and I'll return to that in a second. The second is that the intervention in any event is far too late. The Secretary of State was aware of these proceedings before they were heard in February of last year before Mrs. Justice Simler. It's clear in my respectful submission that in essence, albeit via submissions, the Secretary of State is wishing to put evidence before this court, and the stage at which that should have been done, as indeed any relevant submission should have been made, was at the first instance stage. This application, insofar as it is to do with the adducing of fresh evidence, fails the Ladden-Marshall test. And then third, a final and perhaps subsidiary point, we respectfully submit that the parties shouldn't be put to the trouble of dealing with this application, which will eat into the time allotted by this court for this hearing. But the main one that I'll elaborate upon very briefly indeed is our submission that the intervention serves no purpose.
Yes.
And taking the 2 points made orally by my learned friend, the first is that it would help for the court to have drawn to its attention the significance of this case for the NHS as a whole. In my respectful submission, there's simply no need for the Secretary of State to say that. It was noted by Mrs. Justice Simler, paragraphs 4 and 5 of her judgment. I won't ask the court to turn it up, but in the unagreed bundle, which contains the opening skeleton arguments, it's noted both in the first paragraphs of our skeleton argument and in the first paragraphs of Mr. Leeper's skeleton argument. Indeed, in his paragraph 2, he submits that the potential cost to the NHS would be dramatic. So nobody's in any doubt, or ever was in any doubt, that these cases, or this case, is of general public importance. We respectfully note 2 further points. The first is that the Secretary of State, in fact, is not able to provide any more concrete information about the potential cost of this matter than the parties were. At paragraph 11 of Mr. Sand's first statement, he recognises that he cannot identify with any particularity what the cost will be. But secondly, in our respectful submission, in any event, the premise upon which the point is raised is wrong. We do have a subsidiary irrationality argument. It will only arise if we fail on our main argument, which is about incorporation of terms, because we say that even if the learned judge below was right, that it's the local terms that are incorporated, we say that the way that they were adopted and operated by Derby were irrational, but that's a question of testing irrationality by reference to what happened on the ground. It has nothing to do with the wider implications of the matter across the country as a whole. And similarly, insofar as the relevance is stated to concern the question of contractual interpretation, in our respectful submission, first, the parties are fully in agreement that this is a case concerning alleged breach of contract. There is an argument about which terms are incorporated. There is an argument about the true meaning and effect of the national terms, if we're right, that they're incorporated. But those are matters that must be determined by applying the principles of contractual interpretation. In terrorum arguments that it will be expensive for the NHS if we win, or indeed arguments that it will be costly for junior doctors if we lose, are of no relevance in our respectful submission to the issues that this court has to decide. So in our respectful submission, the there is simply no relevance to the arguments that my learned friend wishes to advance.
It's common ground that the Derby contract was very widely used, whether uniformly used or used in half the trusts in the country or something doesn't really matter. But I think it is common ground, isn't it? It isn't. It isn't peculiar to Derby or to one or two local authority areas.
My Lord, no, in the judgment indeed, her ladyship recorded that it was common ground that the Derby contract is a standard contract used across the NHS.
I remember that sentence.
Failing utterly to find it, as I said, but it certainly is recorded, and it was common ground. So there is no need for the court to be told things by a third party that are common ground. The other point that was mentioned in writing that they're not developed orally was that the allocate computer system is used by many other trusts. That was certainly recognised and common ground before the judge. Indeed, that's of course why this test case is being brought by the British Medical Association. And at paragraph 4 of her judgment, the learned judge records that the allocate system is used in many other trusts, albeit not all trusts, across the NHS. My lords, my lady, as regards the argument that in any event the application is too late, I'll make my points very brief, I'm afraid.
Well, I don't think you have to, Mr. Cameron. It is obviously made extremely late. We bear that well in mind. Any questions? Right, we'll just retire briefly to consider Mr. Lynch's application.
Rise.
Mr. Lynch, we refuse the Secretary of State's application to intervene. We will not attempt to give a formal ruling at this stage, but will incorporate a paragraph or two in our judgment at the end of the case as to why not. But in essence, 1, far too late, 2, should have taken part at trial if at all, 3, the parties, that is the appellant and respondent, are well capable of dealing with these points, and 4, it's common ground that many other trusts use the same contract. And finally, the fact that if you're right, and if the claimant is right, the financial consequences are considerable, is noted, but it doesn't seem to us at present, subject to hearing further argument from the parties, that can affect the interpretation of the contract. Now, having said that, Mr. Lynch, if you and those instructing you think it's worthwhile for you to remain here in case, perhaps improbably, we have a question that only you can answer, then please feel free to do so, but please don't feel under any obligation to do so. If you and the Department of Health team wish to be on your way, then that's fine by us.
Well, my lord and my lady, thank you very much indeed for hearing us. I'm very grateful for that. I'll take instructions, of course, I can certainly, if I may say so, at the very least say that it was kind of you just to say it was improbable that there'd be a situation where only I could answer a question. But anyway, very grateful to you all. Thank you very much indeed.
My lords, my lady, there is one further point, which is the issue of the additional costs of this application. We have served a schedule of costs on the Secretary of State, and the schedule was filed yesterday or the day before, I think yesterday, with the court, but I have copies now. My clients were put to the trouble of engaging in correspondence and drafting a witness statement for this purpose. May I just hand up the statement of costs to the court? It includes the costs of doing that. It doesn't include any leading counsel's fees because I was already on brief and it didn't incur any additional costs in that regard. But it is a request for costs in the sum of £8,146.80. My lords, my lady, unless you wish me to develop the application.
Mr. Lynch, do you want to say anything about this?
No, my learned friends at John Kavanagh QC's instructing solicitors have kindly already provided us with a copy of the calculation. Of course, we have no comments to make.
Right. We'll just rise for a moment to consider this and also to give you a chance, Mr. Lynch, to decide whether you're going to escape before Mr. Kavanagh gets to his feet.
Court rise. Is Mr Lynch staying or going, do you know?
We don't know, he's outside. I think
Oh.
if somebody could tell him that the court's about to come in.
Mr Lynch, are you staying or going? The judge.
I'm staying.
Okay. Thank you. Court rise.
My lords, my lady, if it is all right, I will stay just in case I could possibly help.
Of course, Mr. Lynch. Well, dealing with the costs application, it's accepted inevitably that the Secretary of State must pay the claimants additional costs in dealing with the intervention application. We're bound to say that we think the sum claimed is somewhat ambitious. We will order the Secretary of State to pay £6,000 inclusive of VAT towards the claimant's costs of dealing with the intervention. Right, Mr. Kavanagh, and on with the substance of the matter.
My lords, my lady, as has already been noted, this is a case of general public importance and is brought by Dr. Hallett with the support of the British Medical Association. She is indeed Deputy Chair of the BMA's Junior Doctors Committee. As the court will appreciate, the case concerns the contractual entitlement of junior doctors to take breaks, called natural breaks, during the course of their working duties. And it's common ground that junior doctors are entitled to a 30-minute natural break after approximately 4 hours continuous duty. This matters because if they don't have the opportunity to take these breaks, that affects their safety and their welfare and has consequent effects for patient safety. It's common ground that there's a financial incentive for employers to secure compliance with this requirement and with other controls on hours and on intensity of working. And that is because where there is non-compliance, junior doctors are entitled to a supplement to their pay known as a Band 3 supplement. As the court may appreciate, generally the banding for a junior doctor's rota, or the particular house as it's called that they're working on, is determined by reference to the numbers of hours in a week that they have to work, to the rigours of their rota. But if there are breaches, if there's non-compliance, then they move on to Band 3. And in reality, it's not uncommon for rotas to move on to Band 3. My lords, my lady, I had failed a few minutes ago to find the passage in the judgment where it was said that the Derby contract is a standard model contract. My learned junior has found it for me. It's paragraph 97 on page 155.
Just while I'm looking at the bundles, Mr. Kavanagh, can I just make sure nothing's gone wrong? The skeleton we have from you is 9th May 2018 in support of the permission to appeal application.
My lord, that is right.
Nothing wrong with that. I just wanted to make sure we're singing from the same hymn.
We are indeed. Unusually, we haven't revised the skeleton argument from the position it was in at the permission to appeal stage.
Page 155.
Page 155, 97. Her Lordship records that the Derby contract is a model contract used by all trusts which expressly incorporates those parts of the terms and conditions of service, TCS, relied on in this case so much as common ground. And I'll be coming in a moment, or in a few minutes, to take the court to the relevant parts of the TCS, and indeed the relevant parts of the Derby contract. It was held in this case that if a particular monitoring round which was valid was assessed as being non-compliant, and I'll come back to identify what is meant by those two words shortly, but if there is a valid monitoring round that is non-compliant, then the junior doctors are entitled to move up to Band 3. That's recorded at page 164 at paragraph 132 in the judgment. It's the last 5 or 6 lines. I'll read them out because although it doesn't necessarily appear from the judgment, this was the subject of much argument before the learned judge. She says, "It seems to me that paragraph 21p of the terms and conditions of service provides a right to backdated pay at the higher level if it's shown that the particular post belongs to a higher pay band as the result of a valid monitoring round. Properly construed, this appears to afford a right to a higher pay band rating following a single valid monitoring round that reflects non-compliance with at least 75% return rates. This is inconsistent with the defendant's asserted right to operate a 2 strikes policy as a matter of discretion." What that was about was the defendant's argument, which was that a single non-compliant monitoring round didn't trigger a right to band 3. They had a chance to have a second go. So that argument was advanced but rejected by the learned judge. And indeed it's the subject of a declaration by her in the order that she made following this judgment, her judgment below, just for your note at page 57 of the core bundle.
Yes, and there's no appeal against that declaration by the trust.
There is not. So the central issue in this appeal is whether the trust adequately complied with its obligations to ensure that the junior doctors took their natural breaks in a rota, which was the general surgery F1 rota, over the summer of 2013. As the court no doubt knows, F1 connotes your first year post-qualification. So it's the first of the 2 training years that all doctors have to undertake as soon as they have qualified. The next point, which is now, if it ever was disputed, not disputed, is that the banding entitlement applies to across the board to all junior doctors on the same rota. So if there is a non-compliant valid monitoring round, all of the doctors on the rota move up to band 3. And that is recorded at page 136 at paragraph 23 of the judgment. Picking it up half a dozen lines from the bottom, it is the rota as a whole that is monitored and assessed to determine whether it's correctly designated as belonging to the existing or a higher pay band. Accordingly, all junior doctors on the particular rota receive the supplement if it is payable. And the particular part of the TCS provide that the supplement is backdated to 3 months after the last valid monitoring round, except in certain cases of no relevance for present purposes. Again, there's no cross appeal against that. It is now common ground that all doctors, as one would expect, on the same rota qualify for the same rate of pay. The court will have seen reference in the papers to the 2 monitoring rounds at issue in the present case, known as MR1, monitoring round 1, and MR2, monitoring round 2. And these 2 monitoring rounds usefully exemplify in our submission the problems that the BMA would say are common across the NHS in relation to the monitoring of junior doctors' rest breaks. The reason that they're common is because what we say are the defects are inherent in the software, in the default setting of the software that is used. The software that was at issue in Derby is software called Allocate, used to be called Circadian, so you may sometimes see references to Circadian, but it's the same software. There are at least one other form of software that is used in other trusts called DCS. The BMA suspects that the same problems exist in relation to that software, but that's not before this court. The only, DRS, not DCS. The only issue for this court is the particular situation in the Derby Trust. The judge, just for the court's note, I won't take you to it, the judge noted that this was an issue relating to the software at paragraph 4 of her judgment at page 131. Monitoring round 1 was a 2-week period from the 8th to the 22nd of July 2013. Monitoring round 2 was another 2-week period from the 14th to the 28th of October 2013. As I have already indicated, in a moment I'll take the court through what we say is the structure of the contractual documentation, but it is common ground that the relevant parts of the terms and conditions of service, the TCS, are incorporated into the Derby contract. Read literally, the relevant parts of the TCS would imply that a single failure by a trust to grant natural breaks on a single occasion would trigger a right to band 3 for the doctor concerned. We don't for a moment suggest that's the right interpretation, but if you read the TCS literally, that is what it would mean. Rather, we say that the method of monitoring, the criteria for assessing whether the natural breaks requirement has been complied with, are to be found in a suite of national documents, which we've called the national documents.
What you've just said you're not claiming is that if Dr. Hallett or Dr. anyone else on one occasion doesn't get a half-hour rest break, that would in itself entitle her to a band 3 supplement for backdated for 3 months.
Or even push the whole rota onto band 3.
Her and all her colleagues in the same rota in the same hospital. Oh, yes.
Because if you read the TCS literally, they appear to provide a bright line binding obligation to grant natural breaks, the price of failure for which is band 3. But that's not what anybody is suggesting is the true position. What we respectfully submit is that you look to the national documents, the 3 documents, 2 health service circulars and 1 monitoring guidance document, to fill in the gaps and find what the minimum thresholds actually are for compliance. And the trust has argued that those are not of contractual force, and that the documents that are of contractual force are local documents produced by Derby. And the learned judge agreed with the trust. But before I come to the contested material, may I just identify, I hope for the assistance of the court, several things that are now common ground. The first is, there is now no dispute about how the trust actually conducted its monitoring exercise. No dispute about the criteria and thresholds that it used. The disagreement between the parties is not about what actually happened or how it was done, it's about whether that which happened was compliant with the trust's contractual obligations. And the judge records, perhaps I can just show you at page 145, paragraph 43, in the 3rd line, she notes that there is now no dispute about what the defendant did and how it went about making its calculations, and she goes on later in her judgment to explain the methodology adopted. So happily for us all, we are not having to argue before the court as regards what actually happened. I will try and explain, largely by reference to passages in the judgment, what actually happened, but there isn't a disagreement between us about that. However, for the court's note, there is a detailed summary of how the methodology was operated in our skeleton argument, our closing skeleton argument for the court below, which is in the file headed unagreed bundle at pages 87 to 97. It's unagreed because the defendant, the respondent didn't consent to it being put in the bundle before the court. But the only purpose that I refer to it for is because it sets out in greater detail than we were able to do in our skeleton for this court how actually the arrangements operated. It's at pages 87 to 97. I won't take you through them now unless you'd like me to do so. But just for your note, they are there.
Well, no doubt, out of great sense of propriety, I haven't been given anything called unagreed bundle. I've been given a supplementary bundle, which is pages 1 to 81, and the last item is appendices to the appellant's written closing submissions. We've got core bundle, authorities bundle, supplementary bundle ending at page 81, and the Secretary of State's bundle.
Well, in that case, my lords, my lady, what I'll do, if I may overnight, unless my learned friend objects to it, is make copies for you of our closing submissions for the court below, simply because they add some greater detail to the explanation, which is not an explanation that's contested, as regards how the trust's arrangements worked in practice.
This is not the calculation methods appendix.
No, my lord, I will be taking you to that, and that is, with a, if I may say so, with a bit of guidance, a helpful document. But no, what I'm talking about now is a section of the closing skeleton which provides a narrative text that explains how the arrangements operated. Maybe that this court won't need to look at it because it's clear from the judgment, and I hope will be clear from my oral explanation. But if you were to need any assistance, then the court will find it there. I've just been told that the unagreed documents may be found at the end of the supplementary bundle, but it doesn't sound as if that's right.
No, people have obviously been very scrupulous and said they're not agreed. If there is something you're even alluding to which would be helpful, it would be very helpful to see it now, not after today.
My lords, I have a copy of that bundle. I know it's only one, and of course there's three of my lords and my lady, but I'm very happy to pass that up.
Could and that's very kind of you, Mr. Lynch. Could I just have a look at it and see what we're talking about?
I've been given a second copy.
And I have a third.
I mean, there's the odd red line.
No, it's the third one, I think.
Is that one?
Yes.
Yes. My lords, I haven't got a staple, I'm afraid, or clip, but if I pass that up...
That's fine, so long as it's
That's the right one.
hole punched, that will do.
So, give you that one.
And here's another one. Thank you very much.
Thank you.
It's the passage that begins at the bottom of page 87.
A summary of why the approach taken by the trust, etc.
Yes, in the course of that summary we set out what is now, which has always been common ground as to what the trust actually did. But I hope to be able to explain that to the court without needing to resort to taking you through line by line this document. But it is, I hope, a helpful backstop.
Right.
My powers of explanation aren't up to the task. So there's no challenge to the judge's findings of primary fact about how the arrangement operated, and no dispute as regards how that operated. Secondly, we do not take issue with the learned judge's summary of the case law as regards incorporation of terms, which you'll find at paragraphs 90 to 96 of the judgment, pages 154 to 155. And more than that, my learned friend helpfully indicated at paragraph 5 of his skeleton argument that the principles to be applied are not an issue between the parties. And what I did yesterday was list on a single sheet of A4 what we say the relevant principles are from the authorities. And I'll hand that up, if I may, when I come to the point where we deal with incorporation of terms. But this is not a case in which there's going to need, we hope, to be extensive argument about the content of prior judicial authority. However, the challenge that we advance, we respectfully submit, is nonetheless principally an appeal on points of law. Because we respectfully submit that the judge erred in declining to hold that the relevant parts of the national documents were incorporated into Dr. Hallett's contract of employment and therefore provided contractually binding criteria for the assessment of the outcome of monitoring rounds. And here I come to the crunch. What we respectfully submit is that the relevant national contractual documents requires account only to be taken of actual duty periods that actually happened. We will see that the approach that was adopted by the Trust took account of notional duty periods that did not actually happen. And by the same token as submitting that the national documents were incorporated, we will be respectfully submitting that the local documents were not incorporated and did not support the construction of the contractual obligations that the learned judge found that they did.
Local documents, you say, were not incorporated?
No, the Derby contract, of course, was the head,
Yeah.
the font, so to speak, the fountainhead of the contractual documents. So that is incorporated. But a further, a frequently asked questions document, which Her Ladyship said was incorporated, we say was not incorporated, and a junior doctor's monitoring guidance document that she also said was incorporated, we say was not, although actually there's nothing in it that causes us any difficulty. There was actually a third local document that Her Ladyship doesn't mention, which we say reinforces and supports our contention that it's the guidance given in the national documents that matter. But there is, on this first point, there is a disagreement about which terms are incorporated. The second point is that Her Ladyship found that even if we were right that the national documents were incorporated, she did not accept the construction that we placed on them. So there is, the second point is a construction argument about the national documents. And the third point in this appeal arises only if we lose the first 2 points. If we lose the first 2 points, so that the court agrees with the judge below that the Trust had a discretion as regards the criteria to be used for assessing the validity and compliance of the monitoring rounds, then Her Ladyship found that the discretion was bounded by the obligation to act rationally. And we respectfully submit that the approach that was taken by this Trust was not rational. It didn't pass the rationality test. Her Ladyship rejected our arguments on that, but that's our third alternative ground. But if we succeed on the first 2 grounds, we don't need to rely upon the irrationality argument. So those are the 3 arguments that I will be advancing, if I may, before this court. But a central part of this case concerns the features of the methodology that was adopted by the trust. And we say, well, we don't say this is common ground, that it took account not only of data supplied by doctors who had actually worked a shift, or a duty period as it's called, and who had made a return, but they also took account of duty periods in respect of which the junior doctor had worked but had not produced a return to say whether she or he had taken their natural breaks. And crucially, the trust methodology deemed all of those unreturned, so to speak, duty periods to be compliant. In other words, it was assumed that if a doctor worked a duty but didn't return, it was compliant, that he or she had taken their breaks.
But only those who had worked the shift in question, not those who'd been absent.
Well, that's the second problem I'm about to come to. The first problem, we say, is it was wrong to assume that those who did work but didn't return could be assumed to have had their natural breaks. The second problem, perhaps a more fundamental problem, is that both in assessing validity and in assessing compliance, the trust did not look only at duty periods that were actually worked, but also what are described as expected duty periods. And these consist of duty periods that were not worked because the doctor was on holiday, duty periods that were not worked because the doctor was off sick, duty periods that were not worked because a rota slot was unfilled. This happens in monitoring round 2. Or duty periods that never existed because, as I will explain to you, the way in which the number of expected duty periods was calculated didn't reflect what actually happened in the 2-week monitoring period itself. So we respectfully submit that the trust should not have taken account of these non-existent duty periods, in the sense that they're not periods when a doctor was in the hospital doing her work. But more than that, the trust, for the purposes of compliance, deemed every single one of those duty periods as having been compliant. And this skewed the results in 2 respects. In terms of validity, meeting the threshold that 75% of duty periods had to have a return attached to them, they made it more likely that the monitoring period would be invalid because the 100% from which the 75% was being calculated didn't include the actual duty periods alone. It included actual duty periods plus periods when nobody was there because they were on holiday, and so forth. As regards compliance, the results are skewed in favour of compliance because the non-existent duty periods were all added to the ledger as being compliant duty periods, and because any duty period when a doctor was there but didn't make a return was also deemed to be compliant. And this, we say, got serious consequences, not just for the pay banding, but because it means that trust's artificial use of the data, artificial analysis of the data, meant that a problem with junior doctors, a chronic problem with junior doctors not getting their breaks, could be missed. Because using their methodology, it would look like a compliant duty period, but actually it wasn't compliant at all. And that's, I'm afraid, very much a headline summary. I will, if the court will permit me, go into a bit more detail to explain how this analysis works. But I'm sorry to keep reiterating it, but none of this is in dispute. This is how it operated. The question is whether it was consistent with the contract and whether it was rational. So, validity first. The results of a monitoring round, of a 2-week monitoring round, are only taken into account at all if the monitoring round is valid. If it's invalid, then the pay of the junior doctors continues to be determined by reference to the last valid monitoring round. And in order to be valid, a monitoring round must comply with 2 requirements. The first is the doctor return rate, and that is a requirement that at least 75% of the junior doctors on the rota make at least one return during the monitoring round period. Now, that's the last time I'll mention this because it's not an issue in this appeal. Common ground that the doctor return rate was satisfied in relation to monitoring rounds 1 and 2, and there's no problem in relation to the doctor return rate. So far as validity is concerned, the issue relates to the second requirement, which is called the duty return rate. And this is a requirement that returns are made for at least 75% of duty periods. I will call them duty periods because that's what they're all called, but they're shifts. And the trust determined in relation to monitoring round 2, I should have said monitoring round 2 is the one that tests the issue of validity. The trust determined in relation to monitoring round 2 that the duty return rate was not met, and so monitoring round 2 was invalid. I'm about to show you the figures, but before I do that, it's common ground between the parties that if monitoring round 2 had been a valid monitoring round, it would not have been compliant. So it would have triggered a right to band 3, whatever the position with monitoring round 1. Now what I've done, and I hope it's helpful to the court, I showed this to my learned friend yesterday, is on just over a page I have set out from the judgment the competing figures that the parties have for monitorings round 1 and monitorings round 2. So may I hand that up to the court? This document, if we start with monitoring round 2 towards the bottom of the first page, as I've indicated, the issue with monitoring round 2 was validity. As I've just submitted, it's common ground that if monitoring round 2 had been valid, it would have been non-compliant. That's even on the trust's analysis, thus triggering a right to go to band 3. And that's because compliance, even on the trust analysis, was 74.77%, below 75%. So these figures were worked out to 2 decimal places. And you'll find that paragraph 53 of the judgment, page 147. So monitoring round 2, the crucial question is whether the monitoring round was valid. The trust decided that it was invalid, and the trust identified or calculated a duty return rate of 71.56%, which is of course below 75%, and that's noted at paragraph 51 at page 146. We say that that is wrong, and over the page we just set out without elaboration what we say the right figures should have been. We say that the first reason why the invalidity score on monitoring round 2 was defective was because the trust had treated it as a 22 doctor rota, when in fact there are only 21 doctors on the rota. You'll see reference when we look at the relevant paragraph to a Dr. Mohammed who was doing his own thing. He was actually retaking part of his training. And so instead of being 22 doctors, there was only 21 doctors on the rota, and the trust accepted that this was an error on the trust's part. But if they had done their calculations based on 21 doctors, not on 22 doctors, then even if the rest of the trust's methodology had been used, it would have been a valid duty return rate of 75.67%. Perhaps may I just show the court paragraphs 86 and 87 of the judgment, where we'll see that explained by the learned judge. It's at page 153. In relation to monitoring round 2, the danger of operating on the basis of hypothetical information rather than actual information is illustrated by the fact that the expected figure was wrongly inflated because it was calculated on the assumption that there were 22 junior doctors on the rota, when in fact there were only 21.
I'm so sorry, Mr. Cavanaugh. I thought, which paragraph?
This is 86, my lord, at 153.
Yes.
In evidence, Ms. Atkins, she was the trust witness, accepted that this was a mistake and that this unassigned slot should not have been included. She also expected that the expected duty periods figure for a 21-person shift would have been 206.17 duty periods, which was the figure used for the next monitoring round when the mistake was corrected. The BMA argued that if the 156 duty periods that had been worked and recorded are worked out as a percentage of 206.17 duty periods, the percentage would be 75.67, a valid outcome. So that's the first reason why we say that there was an error in relation to validity. But the second reason, now may I bring you back to page 2 of my little handout, if the calculation had been done the way that I'm about to submit, it should have been done according to the contract, the duty return rate would actually have been 89.65%. And even that is an understatement, because the remaining 10 or 11% of non-returns are mainly due to a doctor called Dr. Clark, who tried valiantly to log on but was prevented from doing so by a hitch in the software. And if the court still has page 153 open, we can see that at 88 and 89. In summary, the BMA argues that the defendant should not have used expected data at all. In fact, there were only 18 days during monitoring round 2 for which returns were not made. If those 18 days were added to the 156 which were worked, as if they were worked duty periods, this means that the total number of work shifts for this monitoring round was 174, which provides a percentage figure of 89.65%, which would be a valid duty return rate. But in reality, the figure is even higher, because the 18 unmonitored duties include 14 that were attributable to Dr. Clark, who attempted to return data but was unable to do so. And her duties were not therefore recorded on the system before the exercise was closed. And the learned judge rejects an argument which actually we weren't advancing, that this was deliberate rather than a mistake.
Why does this matter to the interpretation of the contract?
Because the omission of Dr. Clark's, or the inclusion of Dr. Clark's duties was deliberate and a function, a necessary function of the trust's approach, rather than, as with Dr. Mohammed, a mistake that the trust made and didn't correct. Because I'll show the court in a moment, but the way in which the trust, through allocate, does its mathematics means that the 75% of duty return rate is worked backwards from a total which includes figures that exceed the number of duties that doctors actually worked.
Well, I can see what the result is, but why does it help to look at the result when construing the contract?
Well, it helps for our rationality argument,
Well, that's a different
my lord, but also because my lord may remember that there is an issue, issue in this appeal as regards the approach that we say has to be adopted is consistent even with the national documents. We respectfully submit that in light of the national documents, the approach is very straightforward for validity. You look at the number of actual duties that were done, which is easily obtainable from the medical staffing department. You look at the number of returns that were made and work out as a percentage whether the number of returns that were made is or is not 75% of the total duties that were worked. We say that was the contractual obligation for the trust to comply with. It's not how the trust actually operated, and the trust, conversely, is arguing that the way it did operate is consistent with the contract that it is, the contract terms as it claims them to be. So, my Lord, I hope it will be clear in due course that there is a purpose. I do apologise for taking the court through mathematics, which is not my strong suit, but there is a real, I hope, a value for the purposes of my submissions in taking the court through these figures to explain how things worked and how we say things should have worked. So in terms of validity, as I just submitted, we submit that the position is simple. You look at the number of duties actually worked, you look at the number of returns actually made, and work out if those returns were at least 75% of the number of duties actually worked. What the trust actually did is to treat the 100%, from which the 75% is then calculated, as including duty periods that were not worked, either because the doctor was on leave, on sick leave, or on study leave, and also including duty periods that were not worked because, as with Dr. Mohammed, the slot was unfilled, or because the expected duty periods didn't conform to the actual number of duty periods in the 2-week monitoring round period. And that could happen because each rota was 22 weeks long. Monitoring period was 2 weeks within that. What the trust did through the Allocate software is it calculated all of the total number of shifts there would be over the 22-week period, ignoring leave and ignoring sickness, and then worked out what 2/22 of that figure was. That doesn't work, and they worked that out for each type of duty period: night shift, normal working day. There are various types of shifts, as I'll show you in a moment. In the real world, the number of shifts of these particular types in the 2-week snapshot period, it doesn't conform to 2/22 of the total expected number of shifts, in the sense that the trust is using the word expected. So there was a fundamental reason why, regardless of sickness and regardless of holiday, the figures wouldn't work. The 100% would not exactly conform to the number of duty periods actually done in the monitoring round period. And that is explained, perhaps better than I've just done, by the learned judge at page 151 in paragraph 76 of the judgment. I'm happy to read this to you, or if the court would prefer just to read paragraph 76 to itself, then of course I won't do so. And the very fact that the 100% figure can be a fraction rather than a round number shows that the 100% figure that was being used for validity purposes did not reflect the number of shifts that were actually worked in the 2-week period. And it is a not a round number, as one can see from paragraph 151 of the judgment at page 168. The expected duty figure for a 21 doctor shift would have been 206.17 duty periods. That cannot, of course, actually reflect what happened in the real world. If I could now ask the court to turn in the supplementary bundle to tab 8 to show you how this worked for monitoring round 2. Page 78. Halfway down the page. You'll see that these are figures that were taken from the templates that were recorded at the time. That in the first column for duty type, there are various different types of shift. Normal working day, long day, night, twilight, and normal working day 2. The second column, there are the number of expected shifts worked out as is set out in paragraph 76 of the judgment, which resulted in a total of 218 expected shifts. Then in the right hand column there are the number of returns that were actually provided by doctors who were working shifts during this 2-week period, broken down by the shift type. And that gave a figure of 218 expected shifts and 156 shifts returned. The other figure that's important to note from this page is the very bottom one, the number of records missing, 18. And that's a figure that was admitted in the defence, so it's not a disputed figure. That is the maximum number of instances in which a doctor did a shift but didn't do a return. In fact, for reasons I needn't bother you with, it's probably an exaggeration, but it can be no more than 18 shifts. So if one then turns to page 79, you'll see the different ways in which the calculation could or would have been done. We, the BMA, say that assuming, to the benefit of the trust, that all 18 missing returns were actually duty periods that were worked, then there are 156 duty periods worked and for which returns were provided. The total of number returned in the right-hand column on the other page, divided by 156 plus the 18, which is the maximum number of days worked but not returned, and that produces the figure that you've heard me say already of 89.66%. The trust, on the other hand, used the 156 duty periods that were actually recorded, which is right, but it worked them out as a percentage of the higher figure of 218 expected duties, which led to the figure of 71.56% and an invalid return. And we respectfully submit that the effect of treating the 100% as including a significant number of duty periods that were never worked, whilst only taking into account for the 75%, the returns that were actually made by doctors, means that 100% compliance is never possible. 100% doesn't represent 100% of the duty periods actually worked. It's a higher figure than that, because it includes holiday dates, includes sickness dates, and it includes expected dates that were not, duties that were not actually worked during the cycle that took place within the 2-week monitoring period. And that means that the figures are skewed in favour of invalidity, and that can work to the advantage of a trust, as it did in monitoring round 2, because it means that a monitoring period that would have been non-compliant doesn't have to be acted upon. That's validity. May I move on to compliance?
If there's a non-compliant, if there's an invalid monitoring round, then there's an obligation somewhere in the contract to have a rerun within a specified time, isn't there?
Yes. But what there isn't is an obligation to put them onto band 3 going back to 3 months after the last monitoring round. The second key concept is compliance, and that is the requirement to pay at band 3 if fewer than 75% of the duty periods in the monitoring period are compliant. So if doctors are unable to take natural breaks at least 75% of the time. Again, we respectfully submit that the contract documents make this very straightforward and clear. What you do is you look at the duty periods actually worked, for which returns have been made, and you calculate whether natural breaks were taken 75% of the time. And we say that's what the contract requires. We also submit that there's no problem with worrying about whether that's a sufficiently reliable sample, because the reliability of the sample is determined by the validity stage. If it's a valid monitoring round, then it follows automatically, we respectfully submit, that there is enough material there to let you rely upon the figures that the returns actually made show. And there's no doubt that the trust could have done it our way. The wherewithal was there, and that's recorded by the learned judge at paragraph 55 on page 147. Middle of that paragraph, Mr. Digweed was the witness who was an employee of Allocate. Mr. Digweed gave evidence as to how it operates, and his explanation was broadly unchallenged, though we didn't accept its validity. Although Mr. Digweed agreed in cross-examination that software including Allocate is capable of being designed and set up in different ways, and that the Allocate software could have been set up for NHS trusts to assess compliance by reference to duties actually worked in a 2-week monitoring period. He explained that's not the default setup, and the system applied at Derby is the default setup. Although some trusts make changes occasionally, he said he's not aware of any other trust making a change to the settings applied by default for assessing compliance, and Her Ladyship hadn't been shown any evidence of other software suppliers. So they could have looked only at the duties actually worked and the returns actually made, but that's not in reality what the software did. And what they did instead, with great respect to them, is extremely complicated. We would submit unnecessarily complicated. It's necessary to understand it, I'm afraid, to follow the submissions that both sides will be making. I'm going to do this, if I may, by reference to paragraphs in the judgment, and then again I'll work through the example, this time for monitoring round 1, in the supplementary document. So the first thing that Allocate does is it doesn't use the figures for the actual duties that were worked at the hospital in the relevant monitoring round period. It uses figures for the expected duties. And this means, and I'm sorry if I'm banging on about this, but it is important, this means they took account of figures for duty periods that hadn't actually taken place at all because the doctors were on annual leave or off sick, or because of gaps in the rota, or because the rota during the monitoring fortnight didn't exactly match the 2/22 of the total number of shifts for the particular duty type over the whole rota period. And not only that, but every single one of these duty periods that didn't happen was deemed to be compliant. It was put in the figures as being compliant. The explanation for expected duties is most readily seen in a paragraph I've just invited the court to read, paragraph 76 at page 151, but it's particularly Romans 4 and 5. Perhaps at 3, the system automatically adds in or substitutes data where it's missing. This is done both in cases of duties worked but not returned in the monitoring, and in the case of duties not worked because taken as annual leave, sick leave, or study leave. In other words, it substitutes data for unmonitored duty periods expected to have occurred by reference to the total number of expected duties. And when substituting for unmonitored data in this way, the system assumes full compliance with hours and natural break controls. Thus, where annual leave, sick leave or study leave is taken, or a doctor fails to record their duty, the system assumes that the doctor started and finished their duty at the time set out in the rota and took their natural breaks compliantly with the way in which the rota was established. What that passage doesn't emphasise, although it is mentioned in Romans 2, is that on top of all of that, the expected duties, the total expected duties, is not the total of the number of duties within that 2-week period anyway, because of the 2/22 problem, that the cycle of particular duty types within the 2-week monitoring period is not exactly regular all the way through the lifetime of a rota.
That must have a very marginal effect, mustn't it?
Well, it can have. I'll show you in a moment, but things like night shifts can vary significantly. It is true, my lord, though, that the main distorting effect is holidays. And I won't ask you to read it because it's there in 76, but paragraphs 72 and 75 also make clear that where a duty period is worked but no return is made for it, it's deemed to be compliant. So there's deemed compliance for duty periods worked but not returned, and for duty periods that never ever happened. And we respectfully submit, and I'll come back to this when I'm dealing with the irrationality argument, that is not only wrong in principle and contrary to the contractual obligations, but it also makes no sense to such an extent that it's irrational. But coming back, if I may, to my Lord Justice Bean's question, the reason the expected duties problem is magnified because there are some shifts, some types of shifts, in which the actual number of duties in the 2-week period is fewer than you would have expected if you did the 22-week calculation. Where that happens, that is simply ignored in the allocate process. It's only where the expected number of duties is more than expected. Sorry, I got it the wrong way around. It's only where the expected number of duties is fewer than expected that there is a distorting effect. Where the expected number of duties is greater than the number of actual duties is just ignored in the process. I will show you how that works in practice. Perhaps I'll do that now, because if I could ask the court to turn back to the monitoring round calculations in the supplementary bundle tab 8, this time at page 77, we can see the figures for monitoring round 1. The top set of columns and rows starts with the same 5 different duty types, normal working days. The number of expected duties in the second column is done, as I've said, by taking the total number over the 22 weeks and dividing by 22 and multiplying by 2. Then you get the number of returns that were actually received, and I'll come on to the unmonitored added in a moment. But if you look at the first entry, normal working days, you'll see that there the number of expected normal working days in that 2-week period was only 80, but in fact 90 returns were produced. So there were actually more normal working days worked than the 22-week calculation would have expected. But nothing is done, no adjustment is made in the allocate process to do with that. That's why no unmonitored days are added. If you go down, however, to the night shift, you'll see that 14 days were expected, 10 days were returned, and so 4 are treated as unmonitored. And unmonitored means that they are treated as compliant when we get to the end of the calculation. Then twilight, 14 were expected, 11 weren't returned, 3 unmonitored were added, but the main anomaly arises from normal working days too, because 78 of those days were expected, only 19 were returned, 54 were unmonitored. Many of those were because people were taking annual leave and were therefore not around to record a duty period actually being done. Now, the next section, the middle section of the page, sets out the number of actual work days recorded as 162, and that's the same number as the total in the column immediately above. The number of annual leave work recorded is 25. Now, that's disregarded in the allocate arrangement. So if you're on holiday, you're still supposed to record what you're up to, but that's just ignored for the purposes of the calculation. The total number of records missing is calculated at 47, and the number of natural break fails passes recorded is 108, and the number of natural break fails recorded is 54. That's out of the total of 162. So 54 out of the 162 were fails, 108 were passes. Over the page you can come to see what the competing calculations are. Our calculation is simply that you have 108 recorded passes, 162 duty periods recorded as worked, and that means that only 66.67% of the duty periods that were actually worked had natural breaks taken. So that's why we say it's a fail. The reason why the trust records it as a pass is that they added onto the 162 recorded passes a further 62 compliant duties, and that 62, if you turn back to the preceding page, is the figure that they get from the bottom line of the total in the right hand column of the first chart. So they have added back in those 54 days of normal working days, 3 days of twilight, 4 days of night, when actually most of them will not have been duty periods that were worked but not recorded at all, but mostly they will have been annual leave and so forth. In fact, there was no sick leave in this particular monitoring round. So perhaps it would help if I took the court then to paragraph 84 of the judgment, page 153, where the learned judge helpfully records why we say this is the wrong approach and an illogical approach.
Sorry, could I have the paragraph?
Yes, my lady, 84, page 153. Mr. Wakeford was the BMA, is a full-time BMA official, who also gave evidence. And in Mr. Wakeford's view, the monitored data part of the calculation done by the trust goes some way to recognising that in order to monitor the working reality of junior doctors, the returns that matter are those providing information about actual duty periods. So for the duty return rate, only duty periods actually worked must be monitored. The monitored data figure strips out days off, annual leave and sickness, and looks only at duty periods that were worked and study leave. However, the comparison is then made with expected duties, which includes annual leave, no adjustment being made to the average figure to account for the fact that leave will be taken, inflates the figure against which the actual returns are assessed, and the monitored duties figure doesn't include annual leave. This means that the comparison between expected duties and monitored duties is not comparing like with like. Further, annual leave days are included in the expected figure, but days off are not, which is illogical. And it follows that the defendant's approach, which uses figures for duty periods that never actually took place, is wholly illogical. The duty return rate is not actually assessing whether monitoring rounds were returned by the junior doctors for a sufficiently large number of the duty periods which they actually worked.
I repeat the point I made already. I quite understand why you're introducing us to this material for forensic purposes. But your first argument is on the construction of the contract. You repeatedly go back to your third argument, which is irrationality.
My Lord, yes.
When are we going to come to your first argument?
We'll come to it right away. So, my lords and my lady, what I'm going to do now, if I may, is take the court through the contractual documents, both those that we say are contractual and those that my learned friend says are contractual. And in the course of going through the national documents, I'll make my submissions as to the construction of them, so that I don't do it twice. You'll find all of these documents, except the TCS themselves, in the supplementary bundle, but the TCS, some but not quite all, are also in the judge's judgment. The national TCS is only in the judge's judgment. But I'm going to begin, if I may, with the Derby contract. You'll find the Derby contract in tab 1 of the supplementary bundle. And it's addressed at the very top to Dr. Hallett. The rotation with which we are concerned is rotation 1, August to December 2013, which was banded at 1B. So on the basis of the shifts, it's a 1B banded rotation, and that would, subject to any non-compliance, that would determine the rate of pay that is due. Paragraph 2, your appointment is subject to the terms and conditions of service, and it's common ground, as I've indicated, between the parties that the terms and conditions were incorporated. Over the page, page 2, paragraph 3, at letter D, says that a non-pensionable supplement, as outlined on page 1, will be payable in accordance with paragraph 22 of the terms and conditions of service. That's a reference to 1B. And again at 4C under pay, you'll receive in addition to your base salary a supplement of your base salary for duty contracted at pay bandings, as outlined on the preceding page and set out in 3D. The key paragraph, perhaps for our purposes, is 6A. 6A is headed Monitoring of Working Patterns. It provides that the Trust is contractually obliged to monitor junior doctors' New Deal compliance and the application of the banding system through robust local monitoring arrangements supported by national guidance. You are contractually obliged to cooperate with those monitoring arrangements. Now, pausing there, Mrs. Justice Simler, as she then was, held that that language was apt to incorporate the local arrangements, not only as regards the mechanics, whether people had to fill in a form on paper or fill in, as they did, a computer program, or there's a man with a clipboard and a white coat watching you work. But her conclusion, and one that we are respectfully challenging, is that that language also permitted the Trust to determine the criteria for validity and the criteria for compliance. And I will be submitting that those criteria are actually to be found in the national documents.
While we're on this page, can we do as Mrs. Justice Simler did, I think, cross out the figure 7 where it occurs and cross out 8 under revision to pay banding and substitute 7.
I should show you 6C and D.
Yes.
6C states that the Trust must collect and analyse data sufficient to assess hours, compliance and or to resolve pay or contractual disputes. Therefore, when the Trust reasonably requests you to do so, you must record data on hours worked and forward that data to the Trust. D, the Trust is required to ensure that staff in all training grades comply with the controls on hours of actual work and rest detailed in subparagraph 22A of the Terms and Conditions of Service with the requirements of the working time regulations. The only other 2 provisions of this contract that I ought to show the court are over the page at page 4. There is express contractual entitlement to leave, as one would expect. Paragraph 12.
Yes.
And over the page, again, in the notes, there is a reference at item 4 to copies of HSC Health Service Circular 2000-031, modernising pay and contracts for hospital doctors in training, which may be obtained on request. That is one of the documents that we say, the national documents, that we say contains material of contractual force. In fact, there doesn't seem to be a footnote to which paragraph 4 is attached, but it is in any event one of the documents that's referred to as being available on request by the junior doctor. Just for the court's note, I've already made this submission. The learned judge recorded that this is a model contract that is used across the National Health Service and had been the subject of a national collective agreement. It's judgment paragraph 97, page 155. So it's not a bespoke contract for Derby doctors.
We're calling it the Derby contract because it's convenient shorthand in this case, but it's not as though it was invented in Derby, and presumably in other parts of the country there'll be other names and hospitals on page 1, and thereafter it'll be the same.
Yes. Perhaps it's better title, and indeed it is in the heading, is the F1 contract.
Yes.
It's the contract for F1 doctors.
Yes. Thank you.
I'm just informed by my learned junior that although I said that there's no workable footnote numbering for the reference to HSC 2000-031, apparently that's a typo, and in the national version, note 4 refers to monitoring, but that's not in this particular version.
It certainly doesn't refer to accommodation.
No. So far as the terms and conditions of service are concerned, the parties are relying on the extracts that are set out in the learned judge's judgment. So may I ask the court to turn to that at page 135 from the judgment. I will, if I may, run through and make a few comments on it. Starts at paragraph 19 of the judgment. Paragraph 18b of the TCS states in the second sentence, controls on the contracted hours of duty for each of these working arrangements are set out in paragraph 20 below, and employing authorities shall ensure that these controls are met. They shall keep the working and contractual arrangements under review to ensure that they remain in line with the demands of the post. Hours of duty include periods of formal duty, organised study, training, all rest while on duty, and prospective cover where available. So the primary responsibility for ensuring that these working arrangements, including rest, are complied with, are, as one would expect, vested with what are now trusts. Paragraph 19c provides that a full shift will divide the total working week into definitive time blocks. Practitioners can expect to be working for the whole duty period except for natural breaks. And last sentence, practitioners working on full shifts, which that includes Dr. Hallett, shall have adequate rest during a period of duty. And the controls on hours set in paragraph 20 provide the following controls on hours of duty shall apply to practitioners working full shifts, and they set out a number of requirements. The one that's most relevant to us is on the facing page, paragraph 20H. Employing authorities shall ensure that practitioners in the training grades comply with the relevant controls on hours of duty. Practitioners and their employing authority shall agree to work together to identify appropriate working arrangements or other organisational changes in working practice to ensure that controls on hours of duty, actual work and on rest are met for practitioners in all training grades. And that includes the controls in 22A, which we'll come to in a second, and to comply with reasonable changes, etc. Then at 23, paragraph 21,
Before we go on to paragraph 21, can I just go back, sorry to rewind, to paragraph 18b of the TCS, paragraph 19 of the judge's judgment. It uses, it and 19c use different terms, natural breaks and rest. What's the difference between a period of rest and a natural break?
as my Lord will know, in the Working Time Directive, rest can cover inter-shift rest, daily rest, and weekly rest. What we can tell from 19B, the last line of it, is that this is a reference to rest while on duty.
Yeah.
And rest while on duty can only be a reference to natural breaks, because those are the only rest breaks that happen in the course of a shift. So it's the TCS are the fruits of a collective agreement, and like so many collective agreements, are not perhaps as nicely drafted as those of us who make submissions on them would like, but nonetheless, in my respectful submission, that there's no material difference between the reference to rest while on duty and the reference to natural breaks.
So practitioners working on full shifts shall have adequate rest during a period of duty. Is that equivalent to shall take the natural breaks?
Yes, but we'll see shortly that there is a reference to what the natural breaks consist of.
Yes. Right, I'm sorry, you were on to the next page.
I was on para 23, which is actually 21A of the TCS. Full-time practitioners in the training grades receive a base salary. Part-time, don't need to worry about that. An additional supplement will be paid according to one of the pay bands in accordance with the assessment of their post as described in paragraph 22 below, at rates that are set by national agreement. In the event of a rota without any change in working pattern being shown to belong to a higher pay band as the result of a valid monitoring round, pay at the higher level shall be backdated to the point 3 calendar months after the first day of the previous successful monitoring round, i.e. that which most recently showed the lower pay band. So that's the contractual entitlement to get paid by reference to the results of a valid monitoring round and backdated to 3 months after the previous valid monitoring round. And Her Ladyship, if I may respectfully say so, fairly and properly summarises that in the text which I've already read to you from the bottom of page 136. Paragraph 22, which is set out at the top of page 137, so far as relevant, provides that the assessment of pay supplements for staff in the training grades shall be made as follows. A. Band 3 shall apply to full-time and part-time practitioners in posts which do not comply with the controls on hours of duty described in paragraph 20 above, or with the controls on hours of actual work or rest described below. Refer HSC 98240 and HSC 2000-031, including agreement to modify weekend rest requirements for on-call rotas. That's in brackets, applicable to their work. Now, pausing there, those two referred to documents, we say, are incorporated by express reference by this paragraph, but we do not depend upon this court agreeing with that submission, because we say in any event the relevant parts are incorporated by inference. But the right to a natural break every 4 hours is in Roman 8, so Roman 7, 22A7. Practitioners working full shifts shall have natural breaks as minimum rest during the whole of each duty period, with at least 30 minutes continuous rest after approximately 4 hours continuous duty. So paragraph 18b provides that the controls are applied. Paragraph 20 brings in the entitlement at letter H to the controls that are set out in 22A, and 22A Roman 7 is the provision that sets out the contractual entitlement with which we are concerned. And then at F, Her Ladyship sets out the parameters of band 1B, which is practitioners who work within the controls on hours applicable to their working arrangement as described in 22A, and who work on average 48 hours or less, but more than 40 hours. So that's why Dr. Hallett's rota was described as a 1B rota, but as one can see from the first two lines of 22F, the right to be paid at 1B only applies provided that you're working within the controls on hours applicable. And 22K is a definition of rest which we don't really need to concern ourselves with for present purposes, and 22I is an appeal mechanism which again is of no relevance for present purposes. Paragraph 27 of her judgment, Her Ladyship notes that it's common ground that neither the F1 contract nor the TCS themselves spell out how monitoring should be conducted, what is a valid monitoring round, or what criteria are to be met to establish non-compliance with controls on hours of duty or hours of actual work or rest applicable to a junior doctor's working pattern. And at that point she identifies the difference between us that I'm about to come on to. Before I do so, may I just mention that I had submitted some while ago that if you read the TCS literally and on their own, then any failure, however trivial, in relation to duty periods would trigger a right to payment at band 3. And in my submission that is what one would derive if one read 22A7 and 22F literally, because once you stop working within the controls of hours applicable as set out in 22A, then the right is to a right to band 3. But I said this probably too many times already, that nobody is suggesting that that is the true construction or the proper construction of the relevant documentary framework. May I now come on to the documents that we say were incorporated, and to do so I'll take the court, if I may, to the documents themselves rather than to the references to them in the judgment. And there are 2 health service circulars and 1 monitoring guidance. The first health service circular is in tab 2 of the documents bundle. We can see from the heading that it was originally issued in 1998 and reviewed in 2001. Its heading is Reducing Junior Doctors' Hours, and it is continuing action to meet New Deal standards relating to rest periods and working arrangements and other matters that don't concern us, and it is for action by trusts, amongst others.
And this is the document referred to, is it, in paragraph 22A
Yes.
of the TCS?
One of the 2. And the summary at page 20, paragraph 1, is that this circular provides guidelines, I should say, for trusts and other signatories to the New Deal for junior doctors on the consistent interpretation of acceptable standards on junior doctors' working hours and living conditions. It sets out further points for trusts to action in making progress towards New Deal accreditation. And can I emphasise the words, the consistent interpretation of acceptable standards? Because in my respectful submission, this shows the theme that we will see, which is national standards. Under the heading Action, it says the New Deal hours controls are set out in Annex A, and that the circular provides agreed national guidance in the following areas, only one of which need concern us: rest requirements within New Deal working arrangements, Annex B. And I'll come to those in a moment. But before I do, it's worth looking at the background at 4. Since the launch of the New Deal on junior doctors' hours in 91, there have been major improvements in junior doctors' and dentists' working hours, but we cannot pretend that all the problems of long hours and high work intensity have been solved. There also remains a need for continuing effort by the NHS to ensure that juniors are provided with, then I needn't worry about the living and working conditions, perhaps working conditions, but action on both hours and non-hours issues must go hand in hand to ensure that the quality of the rest, as well as its quantity, is conducive to the training needs of junior doctors and to patient care. If we could then move please to page 24, which is Annex A. This is a table which sets out the summary of hours control, and the relevant column is the third one in, minimum rest during duty periods, full shift, natural breaks. So that's the natural break entitlement, but the note, footnote 3, is important. Information on how to calculate and monitor rest periods is contained in Annex B and Annex C of this circular. So Annex B is about how you calculate and monitor rest periods. And Annex B, at page 25, under the heading Rest Periods and Working Arrangements, says at 1.1, regardless of working pattern, rest must be adequate to ensure safe working for the duration of the duty period. And over the page, at paragraph 5, as a guide, it should be possible for trusts to construct rotas in such a way that out-of-hours rest targets can be met during at least 3/4 of all rostered duty periods. This should be a minimum requirement, and if not met, the trust should urgently review the working patterns or working practices in that unit or specialty. That's where the 75% threshold first appears. That's where it comes
This is out of hours rest.
My lord, it is, but we'll see that it's also treated as a minimum requirement for in-hours rest, and that's at page 29. Summary of rest periods, this is still in Annex B. The full shift, first row, minimum rest is natural breaks, minimum continuous rest guide, at least a 30-minute continuous break after approximately 4 hours continuous duty. At the bottom of the page, in italics, under the heading reasonable expectation of rest, it says in each of these working patterns, rest targets must, note the word must be met during at least 3/4 of all rostered duty periods. Where this target is not met, urgent consideration will need to be given to changing the working pattern or reviewing working practices within the existing working pattern to reduce work intensity to acceptable limits. So that's where the 3/4, 75% applies to in-shift rest periods. And sorry to be melodramatic, but I emphasise the word rest targets must be met during at least 3/4 of all rostered duty periods. That's the first health service circular. The second health service circular is in the next tab at tab 3. This is the other one that's mentioned in 22A of the TCS, and this is the one that is mentioned in footnote 4 to the F1 contract itself. And this was issued in October 2000, reviewed in October 2001, and again is addressed inter alia to NHS trusts, one sees from the first page. And on page 39, there is a summary. This circular sets out for NHS employers the action required to implement the new contract and pay structure for hospital doctors in training, which takes effect from the 1st of December 2000. The associated technical amendments to the terms and conditions, including new pay scales and so on, will follow shortly by way of an advance letter. And I make 2 points in relation to this paragraph. One is the mandatory language, action required to implement, but secondly, that this makes clear, if it wasn't obvious anyway, that this is all part of a package of measures. That it's all interlocking. Under action, next paragraph, employers in NHS trusts need, mandatory language again, to make immediate arrangements to transfer existing junior doctors in post from their current contracts to a new structure comprising basic salary plus banding supplements where applicable. And then under the heading purpose of the new contract, there are several bullet points, the third of which, at the top of page 40, is to provide clear incentives to NHS employers to secure compliance with the new deal and reduce hours and intensity in line with the commitment to implement the Working Time Directive in due course. The details of this new system and accompanying guidelines were negotiated jointly between the health departments and the BMA Junior Doctors Committee, reflecting the need to balance employers' needs to provide the service and the requirements to adequately reward junior doctors for their contribution. So once again, this is part of a nationally, collectively negotiated package. Under the heading monitoring arrangements, key principles and detailed arrangements for the transition period and for ongoing monitoring purposes after the 1st of December 2000 are contained in monitoring guidance on the website. There will be a contractual obligation on employers to monitor hours compliance and the application of the banding system through robust local monitoring arrangements, and on individual junior doctors to cooperate with those arrangements. If either party is not fulfilling their obligations, this could affect the means of determining pay banding, and in some circumstances sanctions may apply. So pausing there once again, this is where we respectfully say that if there is a need for express incorporation of the monitoring guidance, this is where it comes. This is where the detailed arrangements, as well as key principles, are to be found. And as regards the second sentence in this paragraph, we respectfully submit that it is to be regarded as setting out two propositions. The first is the contractual obligation on employers to monitor hours compliance, and we say, as I'll come on to submit, that that is by applying standards, by applying criteria and thresholds set nationally, and then through the use of robust local monitoring arrangements. And we respectfully submit that that is a reference to the practicalities on the ground. My famous man with a clipboard, or filling out the form in a computer. It is not reserving to each trust the power, and I do apologise in advance for this terrible cliche, the power to move the goalposts, the power to set criteria as it wishes to determine whether there has been compliance or not compliance.
It echoes the phrase in paragraph 6A of the F1 contract.
It does indeed. And in my respect, submission, it's probably the other way around. Paragraph 6A echoes this, but either way, my lord is absolutely right.
Well, I think you need to put it the other way if you're going to have this incorporated into the contract.
Yes, I'm sorry, all I meant was probably in terms of the choreography. This was done and then somebody drafted the national contract which was then applied, but it is perhaps of no significance. In the section headed Impact of Contract on the New Deal, it makes clear that the contract provides clear financial and contractual incentives to reduce hours and intensity and to meet current targets and then to meet the working time obligations, recognising that trust pay bills will rise steeply unless they address the problems of non-compliance. The reason I mention this is because of the word clear. In my respectful submission, message, the theme of all of this is there are going to be clear thresholds, clear criteria, and clarity of requirement is a feature of aptness for incorporation into a contract. But that's all I have to show you in relation to the second health service circular. So I move on to the monitoring guidance.
Sorry, before you do that, can I just go back, when we're on page 40, to monitoring arrangements, and the end of the first sentence are contained in monitoring guidelines on the website. Is that what you're taking us to now? It is.
It's the document that they
That's it.
have
Right.
put on the website. And it's at page 42, under the heading Junior Doctor Hours Monitoring Guidance. So there's no dispute at all between the parties that this is the document that was referred to. There is a dispute about whether it gave it contractual force. And may I begin with paragraph 1, because again it explains why this is all happening. Because the New Deal has required an hours monitoring system capable of recording and checking hours worked by doctors against a set of hours limits and controls. This was further refined under the first HSC we looked at, 98-240, which introduced new guidelines and controls on rest periods to make sure that the quality as well as quantity was properly defined, in line with commitment to improve the working lives of junior doctors. So again, I'm sorry I'm making the same point many times, but it's important. It's a reference to a set of hours limits and controls. There is a set of standards that is being applied. There's a requirement for change in paragraph 2 because of shortcomings in local monitoring arrangements, both in terms of coverage and accuracy, no longer sustainable because of the new pay structure that's coming in December 2000. Paragraph 4 is, as my Lord Justice Simon has no doubt already noted, almost verbatim the same language as paragraph 6a of the F1 contract, contractual obligation to monitor and apply the banding system through robust local monitoring arrangements supported by national guidance, and also an obligation on junior doctors to cooperate with those requirements. And paragraph 6 over the page, if the employer and the employee is not fulfilling their obligations, this could affect the means of determining pay banding and lead to financial and contractual uncertainty. 7, to ensure consistency across the 8 English regions in implementing the new contract, the paragraphs below provide a national framework containing an agreed set of key principles and standards together with detailed operational guidance. My respectful submission, it's important that there's 2 different things that are being provided there, some key principles and some standards. And not concerned with whether the principles are incorporated, it's whether the standards are incorporated that we rely upon this document for. But also, yet again, there's a reference to the need to ensure consistency across the 8 English regions. It's not delegating this to the Trust to work out what their standards should be. And then, under the key principles of paragraph 9, the first key principle is an agreed national set of standards and guidance. So national standards. And at 3, third bullet point, targeted and comprehensive, a framework which covers juniors' posts to the extent necessary to provide sufficient information to determine New Deal compliance and pay banding allocations, accurate and transparent, accurate and reliable, open to scrutiny, commanding the confidence of key parties at all levels. So, in my respectful submission, not seeking to argue that the principles are themselves apt for incorporation, but that the standards, we say, are what is apt for incorporation. And at paragraph 10, we now come to the operational guidance which sets out the standards. Trusts need to ensure they collect and analyse sufficient data. Junior doctors are responsible for recording the data and forwarding that at the employer's request. This annex therefore outlines pay banding monitoring requirements and ongoing requirements for monitoring hours in accordance with current New Deal targets. So that word requirements again. In paragraph 12, for measuring compliance against New Deal targets, the following controls or limits must, mandatory word, must be assessed penultimate one at the bottom, natural breaks. And at 13, the New Deal criteria for hours, limits and rest requirements for each working pattern are detailed in HSC 1998-240. Now that is where, in Annex B, the 75% threshold can be found. Paragraph 16 is the paragraph that makes clear that everybody on the same rota gets the same pay. Last sentence, this will enable trust to ensure that banding decisions can be made which accord with the core principle that all doctors working on the same rota or shift are allocated to the same pay band. 17, each duty period must be assessed individually to determine whether the New Deal requirements have been met on the required proportion of occasions as defined in 98-240. That's a reference to 75% of duty periods. But I emphasise the first few words of that paragraph. Each duty period must be assessed individually. We respectfully submit that shows that what matters is what actually happens. When should the data be collected is the next section. At paragraph 20, at the bottom of the page, a monitoring period of 2 weeks is recommended. So that's something that's not mandatory. You could have a longer or a shorter monitoring period, but a monitoring period of 2 weeks is recommended, and we'll contrast that grant of discretion, so to speak, with what comes next. Then paragraph 24, under the heading Sanctions in the Event of Non-Monitoring, says hours information must use agreed local recording methods, diary cards, optical mark readers, barcode readers, which accord with the national framework principles. So it's up to the trust how exactly it does the recording. But the next sentence, hours should be recorded during the agreed monitoring period, preferably during or at the end of the duty period worked, rather than through potentially less reliable retrospective questionnaires or telephone surveys, particularly recommended in the busier acute specialties. Now here, again, the focus is on the duty period worked, as one, we say, would expect. Then there's guidance on what needs to be done locally at 25. Junior doctors and colleagues must be notified in advance of the agreed monitoring period. They must have had some sort of local guidance, top of the next page, and every effort should be made by trust to assist and encourage full participation in the exercise. Juniors should know where to send the information, and adequate collection points should be established. 26 and 27 are very important in our respectful submission. How should the data be collected? Much of the data needed for assessing banding criteria or New Deal compliance, as listed above, will already be available in the Trust's medical staffing sections. Contract of employment, contracted duty periods, calculations for prospective cover, weekly shift and rota timetables. But see what follows. This data will need, mandatory word, to be supplemented by accurately recorded data, e.g. actual length of working week, including early starts, late finishes, rest achieved during the day and overnight, natural breaks, actual working times, as opposed to rostered duty periods. Monitoring may throw up situations where the working reality is very different from the expected working patterns and could indicate the likely source of non-compliance. Now, the reason that I've so melodramatically read out the last few lines of this paragraph is that what is being said here is don't use expected working patterns, use actual working patterns, working times. And it's 27. Under this national framework, a minimum return rate for monitoring data should be set at 75% of all doctors in training in each rota or shift participating in the monitoring round, and at 75% of all duty periods worked over the monitoring period, provided this is deemed to be a representative figure in both cases. This threshold is important for making a valid and accurate assessment of hours worked and rest attained. So this is where the validity criteria of the doctor's return rate and the duty return rate are to be found. And then there is a further section in this document which deals with the nuts and bolts of how you process and analyse the data. And at 29, it says that the system selected for the processing of data should comply with the key principles at Part B, be consistent across trusts, and so on. But all of that is about the mechanism, not about the criteria for validity and the criteria for compliance. So we respectfully submit that what's absolutely clear from the contractual framework is that there are national standards for validity, there are national standards for compliance, which are to be found in these documents, and that the two HSCs are incorporated by reference in paragraph 22A of the Terms and Conditions of Service, and the monitoring guidance is incorporated by reference expressly by the second page of HSC 2000-031. But we go further and respectfully submit that even if there was no express incorporation by reference, there is incorporation by inference, because you need something. You need to fill in the gaps to show what the criteria are for compliance and what the criteria are for validity. And that is to be found, we say, in the national documents, my learned friend says in the local documents. My lords, my lady, I was coming next to the authorities. May I hand up this document which summarises in 5 paragraphs what we say the key principles are? Yes. My learned friend has seen it and said that he doesn't disagree with it. So may I just identify what they are? I may just refer to one or two of the authorities, but very much less than I would if there were disagreement on these issues. The first proposition is that whilst there can be incorporation by express reference, there can also be incorporation by inference, provided that the relevant document or part of the document is apt for incorporation. And therefore, in the last sentence, incorporation by express reference is not always required. Second, a term or a provision may be incorporated into the contract of employment, even if it's referred to in non-contractual language, such as policy or, if it is so, as guidance. That as for aptness for incorporation, a term may be apt for incorporation if it's important, that should be to the overall bargain, such as being relevant to the remuneration package. And aptness is also to be assessed by reference to whether the term is workable. And a useful rule of thumb for...
And perhaps the converse, if the contract is unworkable without it.
Yes, my lord, indeed so. And we'll see, I will take you to Keeley. The term actually wasn't a very happy term, although it was found to be apt for incorporation in the Keeley case. And 5, a useful rule of thumb for aptness is whether the term would have been of contractual force when included in the contract itself. So may I just take the court to 3 of the authorities, and each briefly, to emphasise a couple of points. You should have a separate authorities bundle, I hope. And the first authority I'll take you to, unless my lords and my lady wish me to do so, I won't take you to Alexander and STC, which is the starting point really for incorporation of terms nowadays. The passage at paragraph 31 of the judgment is one that's cited in all the following cases. And may I just mention for the court's note that, though I won't take you to it because all it does is quote from the other judgments, in Sparks and the Department for Transport, a judgment of this court in 2016, Lord Justice McComb very helpfully at paragraphs 12 to 19 collected perhaps the key passages from the earlier authorities. But the one I'll take you to first, if I may, is Briscoe and Lubrizol, which is at tab 3. This was a case about permanent health insurance and about the requirements that Mr. Briscoe needed to satisfy in order to qualify for PHI. And the insurer's policy said that he qualified if he was unable to perform his occupation, whereas the employer's handbook said that you only qualify for PHI if you're unable to perform any obligation. So Mr. Briscoe, understandably, was inviting the court to conclude that the terms of the insurance policy were incorporated into his contract of employment, and that is indeed what the court concluded. The relevant paragraph for present purposes is paragraph 14.
This is the judgment of the majority, is it?
This, I think, it's the judgment of the court. I hope I'm right in saying. No, it's not. Mr. Justice Bodie gave a concurring judgment, and so did Lord Justice
Lord Justice
Ward.
Potter dissented.
So this is the dissenting judgment.
This is,
Yes, it's just in the event, but in my submission and certainly my understanding, he's setting out principles. He dissented, I think, on another aspect of the case. If one turns to paragraph 53, one can see that Mr. Justice Bodie agreed with Lord Justice Potter on the issue of incorporation. And the same applies to Lord Justice Ward 101. Sorry, that yes. So the passage that I'm relying upon is reasonably accepted by the other members of the court. So paragraph 14. In my view, the judge was wrong to hold that the information given in the handbook, which in fact amounted to a misstatement of the test of entitlement to disability benefit under the defendant's scheme as defined in the policy, was definitive of the entitlement of the claimant to benefit. It is of course frequently the case that details of an employee's contract and the benefit to which he is entitled are largely to be found in a handbook of the kind supplied in this case. For this purpose, and depending upon the circumstances, incorporation by express reference in the statutory particulars of employment will not usually be required by the court. Again, it's frequently the case that in the employment context, the language of the handbook, while couched in terms of information and explanation, will be construed as giving rise to binding legal obligations as between employer and employee. So, pausing there, two propositions. One is that it is possible for documents or passages in documents to be incorporated without express reference, though I'll show you that in another of the authorities. But also that even if the incorporated passage is couched in terms of information and explanation, it can nonetheless be construed as giving rise to binding legal obligation. The second authority I'll take the court to, if I may, is at tab 4, Keeley and Fosrock International Limited. Again, a judgment of this court. This time the judgment of the court was given by Lord Justice Auld. And it was
just before we leave Briscoe and Lubrizol. So this says two things. First of all, in the very common case of an employee handbook, that is very often treated as part of the contractual terms. and secondly, that if the employer tries to rely on a document which favours him and which isn't specifically drawn to the worker's attention, then the courts take it in view.
Yes, but also I rely upon it for the proposition that even if the incorporated document is described as information or explanation and not couched in contractual language, nonetheless it will be possible to be given contractual force.
Yes. Doesn't tell you whether it is given contractual force.
No, but it may be. The fact that it is described as guidance or information doesn't disqualify it from having contractual force. Perhaps I will take you to paragraph 31 of Alexander and STC. This was a case about whether a procedure for selection for redundancy was incorporated into the individual's contract of employment. And Mr. Justice Hobhouse, as he then was of course, said that the answer was no on the facts of that case. But there is a famous passage at paragraph 31 on page 292, which is worth, if I may, showing to the court. Having looked at cases on incorporation of terms, he says this: the principles to be applied can therefore be summarised. The relevant contract is that between the individual employee and his employer. It's the contractual intention of those two parties which must be ascertained. Insofar as that intention is to be found in a written document, that document must be construed on ordinary contractual principles. Insofar as there's no such document, or that document is not complete or conclusive, their contractual intention has to be ascertained by inference from the other available material, including collective agreements. The fact that another document is not itself contractual does not prevent it from being incorporated into the contract if that intention is shown as between the employer and the individual employee. Where a document is expressly incorporated by general words, it's still necessary to consider, in conjunction with the words of incorporation, whether any particular part of that document is apt to be a term of the contract. If it's inapt, the correct construction of the contract may be that it's not a term of the contract. Where it's not a case of express incorporation, but a matter of inferring the contractual intent, the character of the document and the relevant part of it, and whether it's apt to form part of the individual contract, is central to the decision whether or not the inference should be drawn. So from the last section of that paragraph, I derive the proposition that something can be incorporated even if it's not expressly incorporated, if it's appropriate to draw the inference to do so, and in so doing, aptness is a central consideration. Further up that paragraph, the fact that a document is not itself a contractual document doesn't disqualify it from being incorporated. And there is reference in particular to collective agreements. And although the three national documents I've taken you to are not in terms collective agreements, it's been made clear that they are collectively agreed between the BMA, doctors' representatives, and the NHS, or the Department of Health. Whilst I'm on Alexander, can I take you to show you a passage that's pertinent to the question of aptness for incorporation, which is at paragraph 27. This is about whether a collective agreement has contractual force. And he says, against the upper hole punch, the contractual intent has to be found in the individual contract of employment, and very often the evidence will not be sufficient to establish such an intent in a manner which satisfies accepted contractual criteria and satisfies ordinary criteria of certainty. Where the relevant subject matter is one of present day-to-day relevance to the employer and employee, and as, for example, wage rates and hours of work, the continuing relationship between employer and employee, the former paying wages and providing work, the latter working and accepting wages, provides a basis for inferring such a contractual intent. And in my respectful submission, by the same token, the aptness, something is more apt to be incorporated if it's regulating your pay, as of course monitoring rounds and the consequences of monitoring rounds do. My lords and my lady, I see the time. I was going to move on next to Keeley and Foster. We'll do this big and medium moment.
Good moment to break off, yes. Mr. Kavanagh, can you give a time estimate for when you're going to hand the baton on to Mr.
Yes,
Luther?
it will be sometime this afternoon. I'd expect to be an hour, perhaps just a bit more than an hour and a half at the most, I would hope.
Yes. Good. Thank you.
All rise.